Adhiniyam. So I hope you remember the discussion on this amendment of pleading. So far we have discussed the point that Order 6 Rule 17 has two parts. The first is discretionary and the second is mandatory. And the court has been given enough wide discretion to allow amendment at any stage of the trial. But then embargo has been put by addition of this proviso, Order 6 Rule 17 proviso, where it says that once the trial commences, then the court will grant amendment only if due diligence is shown. So we discussed that point as well. Now, we were discussing that what are the different principles behind amendment, and when amendment should be allowed and when amendment should not be allowed. So these are basically general points, principles, because case will be decided on facts and circumstances of each individual case. And this is what is the basic concept in law, because every case has its own facts, its own setting. So going ahead with that point, I have discussed the first ground when amendment will be refused, will not be allowed, where amendment is not necessary for determination of real question in controversy. Then the second ground when amendment will not be allowed is when the plaintiff suit would be wholly displaced by the proposed amendment. When amendment will not be allowed, that was the question. So, when plaintiff's suit would be wholly displaced by proposed amendment. These are general points. They're not mathematical rules that it will always apply, but generally this can be illustrated by the leading case on the point is Stewart versus North Metropolitan Tramways Company. Very old case. Tramways Company, 1886. English decision of 1886. So very old case that way. What this case says that in this case the plaintiff sued the tramway company for damages on account of damage caused by negligence of the company in keeping the tramways in defective condition. By their defense, the company denied the negligence. No plea was raised in defense that the company was not the proper party to be sued. So plaintiff files a suit, sues whom? Tramway company, for its negligence. This is a basic fact. By the defense, company denied negligence. Sues for negligence. Clear? Now tramway company gives defense, denies negligence. Says we were not negligent, denies negligence, denies charge of negligence. All right, this is simple fact. no plea was raised in the defense that the company was not the proper party to be sued. More than 6 months after WS was submitted to the court, company applied for permission to amend the defense by adding a plea that by a contract between the company and the local authority, the liability to maintain tramway has been transferred to local authority. So this point should have been brought beforehand. Now see, you write only relevant points so that you can make it simple. After 6 months of filing WS, after 6 months of filing WS, company raises after 6 months of filing WS, company raises now you write like this: company wants to amend its pleading, that is defense, that is WS. This is WS. And uh, by adding a plea that and wants to add plea that wants to add plea that by a contract, wants to add plea that by a contract, the maintenance of tramways has been given to local authority like municipality, etc., local authority, and they are the proper party to be sued. So this was known to you even earlier. The contract was there even earlier. You did not bring it to the notice of court, but the date of application for amendment, the plaintiff's remedy against local authority was time barred. Now the plaintiff's remedy against local authority is time barred. He cannot file any new case against this uh, local authority. Had the agreement been pleaded earlier, it would have been enabled the plaintiff to file a suit against them, so the amendment was refused. Laying down the test for amendment, Pollock said, the test to whether amendment is to be allowed or not is whether or not defendants can amend without placing the plaintiff in such a position that he cannot be recouped, as it were, by allowance of cost or otherwise. Here the action would be wholly displaced by the proposed amendment, and I think it would not be allowed. So, but by this time, plaintiff's remedy against local authority is time barred. Local authority is time barred. plaintiff's remedy against local authorities time barred. So should it be allowed? The court said no. Is this clear? In this context, court said it should not be allowed, as it will displace the whole cause of action. Now then there is another example in your material on page 72 itself, where the whole case of plaintiff along with the admission by the defendant is going to be displaced by having effect of not able to be set right, losing the right that has accrued to the plaintiff by such admission. Such an amendment will be refused. Now, what is being said? In a suit for partition, this will be clear by example. In a suit for partition, an amendment of WS seeking withdrawal of admission was sought for defendant admitted 7 out of 10 properties as joint family property and contested only 3 as exclusively belonging to them. The amendment sought for intended to withdraw earlier admission regarding 7 properties listed in scheduled suit as joint family property. In the circumstance, it was held that when the amendment sought for in WS was of such a nature that it would displace the plaintiff's case and his right to get a preliminary partition decree, the amendment was not permissible. Amendment, if allowed, would change the character of properties from joint family property to non-joint family property, and that would disentitle the plaintiff of a right to partition the property. So that will again cause serious injury. So second example, in a suit for partition, an amendment of admission of 7 properties out of 10. In a suit for partition, an amendment of admission of 7 properties out of 10, admission of 7 properties out of 10 as joint family property was not allowed because it will change the nature of property and will obviously interfere and obviously interfere with and will obviously interfere with plaintiff's entitlement to partition decree. Because if the 7 properties are joint family property, then it is subjected to partition. Only 3 properties will be contested If you accept that 7 properties are joint family property, suppose I file a suit for partition and you are co-partner and I am co-partner. So if you say that yes, there are 10 properties in suit and you accept that 7 properties are joint family property, then I'm entitled to partition being a co-partner. The court will go for partition as far as 7 properties are concerned. Only 3 properties which are not joint family property or contested to be joint family property, that will be subject matter of dispute. Regarding 7 properties, there will be no dispute as such. So if you have admitted earlier 7 properties as joint family property and now you say that no, these 7 properties are not joint family. So this is wholly inconsistent in that sense. And this will obviously affect the plaintiff's right to get preliminary decree as far as partition is concerned. So it affects plaintiff's right which he has accrued. The court says no. But I again and again say this is not hard and fast rule as such. These are just by way of example that these old points are discussed. Not very material now. When the amendment takes away legal right accrued by lapse of time. So if some legal right has been accrued by one party by lapse of time, then this should not be unsettled. When amendment takes away legal right accrued by lapse of time. Amendment takes away legal right accrued by lapse of time. Now you can see this case again, Whedon versus Neal, as an example. No need to remember these names at all. And these are just old examples just for clarification. In this case, A sued B for damages for slander. Slander is basically spoken defamation. Spoken defamation. यदि आप किसी को defame करते हैं by spoken word, शब्द बोल करके, this is what is called slander. तो इसी को slander कहते हैं. So A sues B for slander, that is spoken defamation. Defamation, you know, मानहानि. तो बोल करके मानहानि की अपने. Afterwards applied for leave to amend the plaint in order to add fresh claim in respect of assault and false imprisonment. Later on, A wants to add claim for assault and false imprisonment. FI, false imprisonment. Assault, that is basically giving some kind of slight injury, and false imprisonment where you curtail liberty of somebody and confine him. That is what is false imprisonment. On the date of application, these claims were time barred. Later on, but on this date, the claim of plaintiff becomes time barred. The claim of plaintiff become time barred. But not so, but not on the date of suit. It was not so barred on the date of suit, but now it becomes time barred. So in that sense, the other party has accrued a right by lapse of time that he will not be sued for these things, so assault or false imprisonment. Should you allow this amendment? The answer is no. The court did not allow amendment Court did not allow amendment as if allowed, it will take away as if allowed, it will take away from B the legal right that is defense of limitation. That seat is barred by limitation. That is the defense of limitation accrued by elapse of time. So now this should not be unsettled. Now this should not be unsettled because it has accrued by lapse of time. Is this clear? When the amendment introduces a totally different and new and inconsistent case, when the amendment introduces a totally different, new and inconsistent case. Sorry. When that amendment introduces a totally different, new and inconsistent case, and then generally it will not be allowed. But again and again I am saying that there is no general rule as such. Let's see that in page 72 of your material again. It says the law is well settled that the provision for amendment subject to such terms as the cost and giving all parties concerned necessary opportunity to meet exact situation resulting from amendment are intended to promote the end of justice and not for defeating them. Following words of justice in one of the case are quoted here. All rules of court are nothing but provisions intended to secure the proper administration of justice. And it is therefore essential that they should be made to serve and be subordinate to that purpose, so that the full power of amendment must be enjoyed and should always be liberally exercised. But nonetheless, no power has yet been given to enable one distinct cause of action to be substituted for another, nor to change by means of amendment the subject matter of suit. So, this is now you cannot substitute new cause of action, or you cannot substitute the subject matter of suit. This is not allowed. Of the similar view is the law laid down by Supreme Court in A.K. Gupta versus Samudra Valley Corporation. A party is not allowed to make amendment to set up a new case or new cause of action, particularly when the suit or new case or new cause of action is barred. But it is also well recognized that where the amendment does not constitute addition of new cause of action or raise a different case, but amounts to no more than a different or additional approach to the same facts, the amendment will be allowed even after expiry of the statutory period of limitation. So, amendment can be allowed even after expiry of statutory period of limitation. There is a case, this case is P.A. Ahmad Ibrahim versus FCI. P.A. Ahmad Ibrahim versus FCI. Now what happens in this case? That the amendment would introduce totally a new cause of action and change the nature of suit. It will also introduce a case which is inconsistent with the prayer made in the application for referring the dispute to arbitrator. Prima facie, the amendment in question would cause serious injustice or prejudice to the contention of appellant that the claim of respondent to recover the alleged amount was time-barred. Hence, the amendment was disallowed. What is the factual matrix of this case? Let us know this. This question was asked in your daily judicial services examination. So, this kind of questions can come up in your examination. Be careful. Says there was an agreement between appellant and district manager FCI, and whereby the appellant took to carry out the work of loading and unloading and transportation of food grains on behalf of corporation from 4th April to 73 to 75. The agreement contained a clause for arbitration in case of any dispute. The agreement also contained option clause that the respondent may extend the contract for a period of 1 year. Before the expiry of the contract period, appellant informed the corporation that he was not willing to extend the contract beyond the period of original contract. Thereupon, the corporation invited fresh tenders for the period commencing from 4th April 75. And after that, appellant filed a suit for recovery of this much money from the respondent, being money due on account of pending bill, security, deposit, etc. As against this, respondent corporation filed a suit under Section 20 of Arbitration Act, praying among other things for appointment of arbitrator to proceed to adjudicate the dispute. While this petition was pending, the respondent corporation filed an application for amendment in pending application under Section 20 of Arbitration Act for converting it as a suit and praying for recovery of sum of this much from the appellant. It was this amendment which was the bone of contention, whether or not it should be allowed. The Supreme Court of India, in this case P.A. Ahmad Ibrahim versus FCI, said that amendment would introduce totally a new cause of action and change the nature of the suit. It would also introduce a case which is inconsistent with the prayer made in application of so prima facie, the amendment in question would cause serious prejudice to the contention of the appellant that the claim of respondent to recover the alleged amount was time barred. Hence, the amendment was disallowed. The amendment was disallowed. अब देखो इसमें हुआ क्या है, मैं आपको बता दूं अपनी भाषा में. There is an agreement between appellant and FCI. He is appellant, one who goes in appeal, and another party is FCI. So appellant and FCI has an agreement of loading, unloading. Now just try to understand the facts. And transportation, loading, unloading and transportation of food grains. Transportation of food grains. From 4th April to No, why 4th August? This is wrongly written. 4th April, this is 73 to 73. This is 1973 to 1975. Is this clear? We ले लिया contract. I will do this loading, unloading and transportation from you for next 2 weeks. All right, no issue. Now, there was provision that extension can be claimed, but plaintiff did not claim extension. Appellant did not claim extension. Appellant did not claim any extension. Rather, he said that I will not be able to carry out this further. So please excuse me and clear my dues, etc. Provision for extension was there, but appellant wanted to withdraw after April 75. April 75, all right? April 75. The agreement also contained an option clause that the respondent may extend the contract for a period of 1 year. Before expiry of contract, appellant informed the corporation that he was not willing to extend the contract beyond the period of original contract. And then corporation invited fresh tenders and appellant filed a suit for recovery. Filed a suit for recovery. Suit for recovery of amount. All right? Anybody will do this? भाई मेरे पैसे दे दो फिर काम खत्म करो. Filed suit for recovery of certain money. As against this, the respondent corporation filed a petition. Now, obviously, he filed it in a court. Appellant filed it in a court. Respondent says that court does not have jurisdiction, rather Section 20 of Arbitration Act will apply. Raised objection and filed petition under Section 20 of Arbitration 1940 Act. This was the old Arbitration Act. Now there is 1996 Act, but at that time it was 1940 Arbitration Act. Raised objection and filed petition under raised objection and filed petition under Section 20 of Arbitration Act. Arbitration 1940 Act. Praying among other things for appointment of arbitrator to proceed to adjudication. While this petition was pending, the respondent corporation filed an application for amendment under 20 for converting it as a suit. Then wanted to amend it, for converting it as suit in a civil court and praying for recovery of another amount. Earlier he claimed 2,05,000, now it is 1,74,000. Converting it as a suit. And for recovery of another amount. Is this clear? It was this amendment which was the bone of contention. Now, will you allow this or not? That is what is the question. Supreme Court said that amendment, if allowed, will introduce totally a new cause of action and change the nature of suit. It would also introduce a case which is inconsistent with the prayer made in the application for referring dispute to arbitrator. Inconsistent, please. First you said that I will file application before arbitrator, and then you are yourself saying that I will amend my now petition or written statement and I want to bring it before the court. So should it be allowed or not? That is the question. Inconsistent. You cannot blow both hot and cold. First you are saying that case should be filed before arbitrator, and now later on you want this suit to be filed before civil court. So while this petition was pending, the respondent filed an application for amendment, all right. The Supreme Court said that amendment would introduce totally a new cause of action and change the nature of the suit. It would also introduce a case which is inconsistent with the prayer made in application for referring of appellant that the claim of respondent to recover the alleged amount was time barred, hence the amendment was disallowed. So this amendment is time barred. Now amendment is barred because it will introduce a new cause of action. It would introduce a case which is inconsistent with the prayer. Inconsistent with the prayer, earlier you made the prayer that I want to bring this case before arbitrator, and now you are saying by amendment that now I want it to be decided by a civil court. So this is inconsistent. First you blow both, you cannot blow both hot and cold. You cannot eat cake and have it too. No, you cannot have and eat both. So now it says, prima facie the amendment would cause serious prejudice to the contention of appellant that the claim of respondent to recover the alleged amount was time barred. Hence the amendment was disallowed. Amendment was disallowed in this case. Amendment was disallowed because it raises inconsistent plea. Inconsistent because once you say that this will be before arbitrator, and now you say that no, it should be before civil court. Ahmad Ibrahim versus FCI. And then it says, prima facie the amendment would cause serious injustice to the appellant that the claim of respondent to recover the alleged amount was time barred. That claim was also time barred. Where court has claim of filing suit. Amendment was disallowed because it raises inconsistency. Claim of filing suit in court when already objection raised for arbitration. So these are inconsistent things. Once you say this should be raised before arbitrator, and now you say no, 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 it should be by court. So you cannot blow both hot and cold. This should not be allowed. This should not be allowed. This should not be allowed. Is this clear? So in these cases, amendment will not be allowed. In these cases, amendment will not be allowed. When application for amendment is not made in good faith. So just have a glance, nothing great in this. Now we'll move further and we'll see the different cases and we'll talk about further points. And we'll talk about its applicability in specific relief act, writ proceedings and arbitration proceeding as well. Now in the second step, we'll be studying about various case laws. Just have 5 minutes breather, we'll discuss case laws now. So now we are going to study the cases, and in the first case, this is Sonia Mehra versus Manisha Rawat. This is Delhi High Court judgment. Sonia Mehra versus Manisha Rawat, decided on 21st August of 2015. If you read this case, you can understand this by reading this. Suit for a specific performance has been filed in year 2008. A written statement had also been filed in November 2008. In order to seek amendment, it is necessary to satisfy the court that the facts sought to be pleaded by way of amendment could not be pleaded before commencement of trial, despite due diligence, because trial has already commenced. Petitioner has not pleaded in preliminary objection number 4, the factum of death and his 3 legal heirs. So basic question is, I hope that you understand the question. And the question is very basic one. Here the question is that plaintiff's evidence was closed. Petitioner also filed her affidavit as defense witness. All right. Now petitioner seeks amendment in WS, raising plea which were well within her knowledge at the stage when the written statement was filed. Question is, should it be allowed? Should amendment be allowed? And can you show due diligence? No. So, should you be allowed? No. The answer is no. You go to the factual metrics, law is clear, I hope, in your mind. The basic point is that here one party is saying, whoever may be the party, plaintiff, defendant, petitioner, respondent, you are not concerned with that fact. Should pick the point. The point is this, that the plaintiff's evidence is closed. Defense evidence is also over. Now one party says, I want to amend my pleadings and I want to bring some facts before the court which I could not have brought earlier. Now, was it not within your knowledge earlier? It was very much within your knowledge. You are all aware, so why did you not? Can you prove due diligence? Order 6 Rule 17 provides in proviso that if now even after trial has commenced, we can allow amendment of pleading if you can prove due diligence. Can you prove due diligence? That is the question. The answer is no. So should you be given opportunity of amendment of pleading? The answer is clear, no. Now, how this is decided? Now, you see the factual matrix, because in your examination, facts will be there. And I have given you this lecture on YouTube, so please listen to that. There is great detail in that lecture. I have asked you to listen to that. Now, it says the petitioner is aggrieved. Aggrieved means he is not happy by the order dated 19 February 2015, whereby 2 applications filed by her, one under Order 6 Rule 17 CPC with a prayer to amend the WS, and second Order 9 Rule 7, with which we are not concerned right now. We are not going to discuss that. We'll discuss that later on. That is not the issue here. In the civil suit filed in here, the petitioner was sued as a defendant seeking a decree for a specific performance in respect of the agreement to sell and purchase, as well as decree for possession and injunction. So obviously, whenever there is a kind of agreement to sell the property and the property is not sold, then you bring a suit for a specific performance in respect of that agreement to sale, and then you also pray for possession of the property, and you also file a suit for injunction. So these are all things which are done here. Injunction to restrain the party to sell the property to somebody else. So this is what is done generally. A written statement was filed. Is this clear? And this is how it is done. Generally, a lawyer will not accept anything, so this is done here also. It says, para 11 plaint is wrong and denied. This is WS. This is written statement. Para 11 of the plaint is wrong and denied. This is how you write WS. It is submitted that on a sum of 2 lakh was paid by plaintiff as loan and not as bayana or advance. So I have not taken any money to sell the property. It is denied that on this date further consideration of rupees 1 lakh was paid. So everything is being denied. It is denied that 20th June 2000 plaintiff served any legal notice. No legal notice. Denied. It is further denied that there is any cause of action. This is how you write WS. This is how you write WS. So if you are asked a question how to write WS, you can see this. It is denied that on 26th that defendant refused to perform her part, as there is no question of such action. Because I have not taken any money and there is no consideration, so I am not bound to. No? So many points. First is para 11 is denied. Sum was paid by the plaintiff as loan, not as bayana. This is contradiction. You are saying that I have given you bayana. I say that no, you have given me loan, no bayana. It is denied. This is third. This is first. Second, this third, 2 June 2005, further it is consideration of as alleged. It is denied. The third is denied. Plaintiff served any legal notice, it is further denied. Number 4. It is denied that there is any cause of action. Number 5. It is denied that defendant refused to perform her part. There is no question of such action because there is no duty to perform that because there has been no payment as such. So all are denied. This is not in this Order 6 Rule 17, but I have just told you. Now you read cases like this. Lawyer comes and lawyer says that purpose of seeking amendment in WS was to give necessary details in respect of loan transactions. So we want to bring necessary details in loan transactions. Was it not available to you earlier? Everything was available. And also to bring on record the facts and circumstances about the real transaction. You know that what was the real transaction between the parties. Could have pleaded this before the court earlier. So you want to bring necessary detail. That is your argument. Respect of loan transaction. I want to bring the record, despite her due diligence, could not raise this plea at the stage of filing WS. Is this tenable argument? Also wanted to place on record the facts relating to friendly transaction. There is no sale and purchase. It was a friendly transaction between plaintiff and defendant, as well as circumstances under which the loan amount was given. So I want to bring all these things. So you could have brought it earlier. Petitioner also wanted to raise preliminary objection about the enforceability of agreement and also plead financial crisis. They are showing that there is some financial crisis and that is why we have taken loan. We have not taken any consideration. We have not agreed to sell the property. That is what is their averment. So it was all known to you earlier also. Why now? Is this clear? This is how they want to argue before the court. Mr. S.P. Kalra says, learned senior counsel for petitions after death of her husband, petitioner is not the sole legal heir as she has two children who were minor. So they are bringing some facts in their favor. Minor. She has two children. She was not in a fit state of mind. Even her counsel, Mr. Khattar, was ill and later on expired. Her lawyer died. Amendments sought are more in the nature of explaining the facts and circumstances already pleaded. So it is not going to cause prejudice to the other party. That is what is the plea. And it is necessary to be brought on record for proper adjudication of the controversy. No prejudice would be caused. That is how you will argue the thing. If you read the cases, this is how. See, necessary, no prejudice. These are all things which you are required to bring in your answer and examples. Learned senior counsel for the petitioner has relied upon Mahila Ramkali. Now, in Mahila Ramkali, in peculiar facts, now, even after lapse of 40 years, amendment of plaint was allowed by the apex court, observing that rules of procedure are intended to be handmade to the administration of justice. But it will be allowed after 40 years when it is required. The question is not of time. The question is of whether there is necessity to allow amendment or not. The question is not of time. See, this is how lawyers will mislead the court because they are expert in winning their case. It is not said in negative sense. I am saying in positive sense that, see, it is legal acumen. How can you divert, deflect? And that is how you can win case. Now, this is not question of time, my dear friend. This is question that now whether there is any requirement of allowing amendment. That is what is the question. I have considered the submissions made by the learned counsel for the petitioner. By common order dated 19th February, learned trial court dismissed both the application filed by the petitioner. Application has been dismissed now. So we do not find any substance. So application under this was dismissed by trial court, noting that amendment to incorporate the state of mind of the defendant at the stage of filing WS is without any basis. And so far as legal issue challenging enforceability is concerned, the same being a legal issue can be argued at this appropriate stage. The amendment has been declined by learned, observing that in the instant case, the evidence by both parties stand concluded. This is also a reason. The case was at the stage of final argument, and you have not been able to prove any kind of due diligence. Further, there is no merit in the said application. Now, the question which can be framed by the court that requires consideration by this court is whether amendment at the stage of final argument was necessary. Whether amendment at the stage of final argument was necessary and it satisfies the test laid down in proviso to Order 6 Rules 17. Before examining the above question, it is necessary to refer to the case law relied upon by learned senior counsel for the petitioner and its applicability in the given facts. Placing reliance on the decision of Mahila Ramkali, learned counsel for the petitioner referred to para 17 of the judgment which are extracted hereunder. So you can see it here. During the course of hearing, an application is filed by one of the parties under Order 6 Rule 17 that the respondent this fails under class 17 of the Madhya Pradesh Land Revenue Code. This amendment at this stage in fact cannot be allowed because the same is going to totally change the nature. The suit is filed in the year 1964 and the suit is filed on the premises that Ramkali Devi has inherited the property from Ajudi Bai on the basis of will. By amendment in the pleading, Dinesh, Satish, Sanjay and Rajendra have joined as party. That amendment was incorporated on 1994 and their names were added as plaintiffs. In the cause title also the word plaintiff is substituted by the word plaintiffs. However, there is no amendment in the amendment made in the rest of the pleadings in the plaint. In such circumstances, now it will not be in interest of justice to allow the application for amendment, which totally goes to change the premises of the suit after a lapse of more than 40 years. In the present case, the plaintiffs have based their title solely on the basis of will executed by Ajudi Bai and therefore allowing an application for amendment making claim on the basis of inheritance, that too through Hardayal, cannot be permitted. Hence, the amendment application is rejected. It appears that while disposing of the bill, the High Court has not gone into the amended plaint. By amendment, the plaintiff appellant not only sought to add the names of Dinesh, Satish, Sanjay in the category, but also sought to make necessary amendment in para 3. The amendment sought to be incorporated is reproduced hereunder. विकल्प में यदि वसीयतनामा वैध न माना जाए तो भी अजूदी भाई के करीबदार वैरीज वादिनी के लड़के राजेंद्र, दिनेश, सतीश और संजय की है जो अभी नाबालिग है और यहाँ दावा उनके हितों को रिप्रेजेंट करते हुए उनकी मालिकी के आधार पर भी प्रस्तुत है। वादिनी के देख रेख में लड़के रहते हैं। गर्ज यही है कि हर हालत में प्रतिवादीगण की कोई स्वत्व मुकाबल वादिनी एवं उसके लड़के नहीं हैं और वादिनी विवादाग्रस्त आराजी का कब्जा अपने तथा लड़कों को और से पाने की प्रार्थना है। As translated in alternative, if the will is not held valid, yet the plaintiff's sons, who at the present are minors, are near relations of Ajudi Bai, and this suit is submitted to represent their interest on the basis of their ownership. The sons live in care of plaintiff, meaning thereby in every condition there is no right of defendant competing plaintiff, and the plaintiff herself and on behalf of her son is entitled to get possession of the son. It is well settled that the rules of procedure are intended to be handmade to the administration of justice. Party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or even infraction of the rules of procedure. The court always gives relief to amend the pleading of the party unless it is satisfied that the party applying was acting mala fide or that by his blunder he had caused injury to his opponent which cannot be compensated. This is the case where the proposed amendment has to be dealt with Order 6, Rule 17 as it stands amended. The provision to Order 6, Rule 17 reads as under. All right. This is talking about, but as far as this case is concerned, now in this case, Mahila Ramkali, so the law is written here. Basically, it is said that the rules of procedure are intended to be handmade to the justice. A party cannot be refused just relief merely because of some mistake. So, if that was claimed on the basis of will, and later on it comes to the knowledge that it could have been claimed on the basis of inheritance, inadvertence, or even infraction of the rules of the question is, now the court will grant this amendment to allow justice to prevail, or court will not grant amendment to allow injustice to prevail. What should be done? The court takes favor of justice, and court said even after lapse of so much time I will allow this. I will allow this to happen, no issue. But you tell me, in this case which we are reading right now, Sonia Mehra, is there anything like that? There is nothing like that. So Mahila Ramkali is not attracted here at all. Mahila Ramkali is clear case, where you based your claim earlier on will, but you did not claim it on the basis of inheritance. It came to your now mind later on, and you are praying now to the court in sum and substance that my plea should be allowed even on the basis of inheritance, and it should be allowed to be brought before the court. The court says that it can be done even after so much of lapse of time. I do not worry about that. Rules of law are not rules of mathematics. That there are mathematical rules, oh, it cannot be done after lapse of so much time. This is not like that. Generally, it will not be done. But if there is, well, it says it always gives relief to amend the pleading unless it is satisfied that the party applying was acting mala fide or that by his blunder he had caused injury to his opponent which cannot be compensated by an order. There is nothing like this. There is no harm to the other party. There is no harm to the other party. There is nothing like that. So why will not allow? Now it comes and it says, Order Rule 617 as it stands amended by CPC 2002 recognizes the power of court to allow amendment with certain limitations contained in proviso added to the rule. Already we have read this. In order to find out whether application filed by petitioner seeking amendment of WS satisfies the requirement of provision of Order 6 Rule 17, legal position is well settled. That the power of court to grant amendment is with limitation contained in provision added to Rule 17 of Order. Now in provision, in proviso, these are all written wrongly. Many mistakes are found these days in when this kind of proviso added to Order Rule 17 of Order 6. It is not provision, and it is also not provision. That is what I understand. It is proviso. The question whether pleadings can be directed to be amended after the commencement of trial has been considered by Supreme Court in decision reported in Vidya Bhai. And this is a good point, that can it be done even after now this evidence is closed and after commencement of trial, can it be done? That is the question. Can it be done even after commencement of trial? So see what Vidya Bhai says. Just read it. There is no rule which prevents this. Proviso says, but proviso says that if you can show due diligence, I have no issue. So Vidya Bhai versus Prem Padma Latha, AIR 2009. Vidya Bhai is plaintiff but filed a suit for a specific performance of agreement of sale. Written statement was filed when the case was at the stage of cross-examination. An application under Order 6 Rule 17 was filed. The amendment application was dismissed. The order rejecting the amendment was challenged. In exercise of writ jurisdiction, High Court of Karnataka allowed the amendment. Allowed amendment. Why it allowed amendment? Observing as under. Stage at any stage. That is written in Order 6 Rule 17. It says filing of affidavit by way of evidence is not a good ground to reject this amendment application. It is not out of place to mention that the parties must be allowed to plea, must be allowed to plea. Such a valuable right cannot be curtailed in absence of good ground. So there should be good ground to curtail it. Aggrieved by the said order was filed impugning the High Court order allowing the amendment, the relevant paras noting the rival contention and explaining the legal position as under. Now, the question therefore which arises for consideration is as to whether trial had commenced or not. In our opinion, it did. The date on which issues are framed is the date of first hearing. After trial commences, then your right or your issue is the date of first hearing. Provision of the Code of CPC envisages taking of various stages at different stages. Filing of an affidavit in lieu of examination in chief, in our opinion, would amount to commencement of proceeding. All right. Oh, this is going for 227 now. See para 14. Now coming to this case, see how beautifully it says, a bare reading a bare reading of WS makes it clear that at the time of filing WS, more than 6.5 years had elapsed from the date of death of her husband. No physical or mental disability has been pleaded in the application, which could have affected the capacity of petitioner to plead all the pre-existing facts. The facts now sought to be pleaded in WS by way of amendment do not satisfy the test laid down in proviso to Order 6, Rule 17. Thus, petitioner is not able to derive any advantage by placing reliance on Mahila Ramkali. It is worth noting, बहुत सारी बातें बताई गई है बीच में, but main point वही कि देखो, once the trial has begun, can we allow amendment? That is what is the basic question. That is what we are required to understand, and this is what is being answered here. The plaintiff's evidence was closed. That is what is the point. And thereafter, petitioner also filed her affidavit as defense witness, which is placed on record date of it after framing of issues. When the trial commenced, the parties availed opportunity to petitioner cannot be permitted to seek amendment in WS, thereby raising pleas which were well within her knowledge at the stage when the WS was filed. Can you see this? Since the impugned order disallowing the application under Order 6 does not suffer from any error of law, no interference is warranted by this court. Now, another prayer is not required. So, basic point is this, that it was well within your knowledge, so why did you come after? But see, reading of these cases will help you in understanding of writing of judgment, writing of plant, writing of even WS. So, by reading cases, you learn a lot. Don't avoid reading cases, though it may be a little bit lethargic sometimes. Because you cross, now you have many cases written in between which takes many things, and you have no full detail of those cases in your referred, because it is referred here, some cases have been referred in this case, and you may not have all facts written here. So, that may not look sometimes very, very interesting, but it is very interesting in the sense that you learn how to write judgment, you learn how to plead the case, how to raise arguments, how to apply law in particular fact situation. So, you see this, the lady is saying that my husband is dead. The lady is saying that my lawyer was also ill. The lady is saying that the children were minor. All agreed. The lady is saying that it was a loan transaction, not a sale transaction. Lady is saying that it used to happen between our brother and other party. So nothing great here. Everything accepted. Okay, all right. But now you seek amendment of pleading, that is in WS, after conclusion of evidence. Is it justified? Can you show due diligence? The answer is no. And these are not necessary for determination of real issue. You want to bring now particulars of loan transaction. So, this is not going to help at all. You were aware of all these things even before. And if you want to bring it, you could have brought it earlier. And there is no proof of any kind of mental and physical disability on your part. So, your plea is now not bona fide. It is not bona fide. It is just a delaying tactics. It is just diverting tactics. The court is not going to oblige you in that sense. Is this case clear to you? No. Is this case clear? Sonia Mehra versus Manisha Rawat. Now, then there is another case. I should move to another case, my dear friend. So you have another case. After this Mahila Ramkali, you have many cases. This is Sarabjit Kaur, which I have given you yesterday, no? Sarabjit Kaur versus Joginder Singh. Sarabjit Kaur versus Joginder Singh. Sit there. Sarabjit Kaur versus Joginder Singh. Sarabjit Singh versus Sarabjit Kaur versus Joginder Singh Bamra. Now, here see the law, it says, as the amendment sought for in the present case is necessary for the purpose of determining the real question in controversy, and the trial court should have allowed the prayer for amendment in view of above, this court is of the view that the proposed amendment was required to be allowed by the court below so as to determine the real controversy. So now we are required to understand that whether it was necessary to determine the real question in controversy or not. So let us see this case. Relevant facts. Now let us read the fact. Now here it is the relevant facts. In any judgment writing, first you write the facts. Any judgment writing. Petitioner had filed suit seeking relief of injunction against alienation of property, as well as declaration seeking cancellation of the sale deed or transfer deed, if any, executed by the defendant number 1 in favor of defendant number 2 and 3 in respect of the suit property. The said suit was filed on the basis of agreement of sale dated this, allegedly executed by defendant number 1 in favor of plaintiff. So, plaintiff files a case against a defendant for relief of injunction, that he should be restrained to sell the property, or he should be restrained to alienate the property. Alienate means transfer, basically. He cannot gift, he cannot sell, he cannot transfer. That is what is alienation. Alienation means basically transferring. This can be by different methods, by gift, by sale, by settlement, or by exchange, many methods, something like that. So, petitioner had filed suit seeking relief of injunction against alienation, as well as declaration seeking cancellation. Cancellation of the sale deed. If it is sold to somebody else and I was entitled, so I will ask for cancellation of sale deed. So that is what they did. If any, executed. The said suit was filed on the basis of agreement of sale. Now, the question is, when there is agreement of sale, then you should go for enforcement of that agreement. You should go for a specific performance, or you should demand the money back. But he did not do it. Now let us see further. The grounds in application seeking amendment were that the plaintiff is an illiterate lady. Now see the grounds. Now we are concerned with this. The grounds in the application for seeking amendment were that the plaintiff is an illiterate lady and was not made aware by the previous counsel and was not properly guided, and that is why she could not file the suit for possession by way of a specific performance of agreement. So this is our ground, that my lawyer did not suggest me well, so I would have filed a suit for possession and a specific performance of agreement. I should have claimed possession of the property and I should have filed suit for a specific performance of the agreement, which I could not do. So now she wants to amend her plaint and she wants to bring the ground of seeking possession along with this specific performance of the agreement. Is this clear? Plea was taken that the application for amendment is not maintainable, as on the date of filing of suit itself, main suit for permanent injunction was not maintainable. So trial judge said that, see, this is how you learn the law. What trial judge says? Trial judge, while passing the order, dismissed the application for amendment on the ground that on 4/1/14 suit for permanent injunction could not have been filed by the plaintiff and the same was not maintainable, but suit for a specific performance was to be filed, and as the main suit itself is not maintainable, the amendment, as the amendment sought for could not be allowed. If the main suit is not maintainable, what will be done with the amendment? So this is gone. As on the date of filing of suit, main suit for permanent injunction was not maintainable, as the target date for execution of sale deed was 2012-2013. And for that, plaintiff was required to file suit for specific performance. Now, of agreement of sale dated 21-2013. So he should have filed suit for a specific performance and not for permanent injunction. Learned trial judge, while passing order under challenge, dismissed the application for amendment on the ground that on 4/1/2014, now the date has elapsed, 2012-2000 has gone. On 4/1/2014, suit for permanent injunction could not have been filed, and the same was not maintainable. But suit for a specific performance was to be filed, and as the main suit itself is not maintainable, the amendment sought is not maintainable. So he refuses this. He says, no amendment will be allowed. Learned counsel for petitioner mainly submitted that the applicant was an illiterate and was totally dependent on legal advice from her counsel. Now, you say prima facie, is it necessary to allow this amendment for determination of real issue? If there is an agreement and the lady is seeking that agreement's enforcement, which is well within time, and the lady is seeking possession on that basis, what wrong is there? And will it injure the other party? I don't think so. So you read this. So she says that she got legal advice. And in many cases, I have told you yesterday also, in many cases, lawyers do not give proper advice. I have personal experience of this. In two of the cases, and in both the cases, lawyers were not having adequate knowledge of the subject, and that misled and that created enormous problem for me. One was related to MACT claim and another is related for recovery. Even in recovery suit, what I found later on, it is case of 2013 and it is still languishing. It was pending before the court even today, but the lady judge is on the leave. So the date has been fixed in April 2022. So that is very unfortunate. That will be 10th year now. And my 50 lakh rupees has been taken by that person concerned, Mr. Garg, in 2013. So now he says that you gave me some money and that money was 10%, it was bayana. So he says that is bayana. That is bayana. So I am not going to return you that bayana money. So obviously he is admitting that he is admitting the fact that the other money which he has taken out of 50 lakhs, 13 lakh according to him is bayana. So you give me 37 lakhs. So if this would have been filed well before in 2013-14, it could have been done. And I never saw that application which is being drafted, because generally lawyers are considered to be learned and competent, but unfortunately this could not happen. And it was to be filed today. But even today it is not filed. I'll receive the document and I'll sign and then it will be filed. So this is really unfortunate that we are not having proper legal knowledge even if we are practicing in court. And that is why it is necessary to read cases. I will suggest everyone to read cases. This is very important. It is an eye opener. You will not get such things in books. I must tell you, if you are under darkness, if you think that I can now, even the teachers are not interested in reading cases. Now leave students. Even lawyers are not interested. If you read 4 or 5 cases every day, I think you will have huge legal knowledge and you will have huge legal acumen to win cases, and you will be very successful lawyer or officer or a judge. I tell you, now in your life, if I teach, I should be able to teach well. If you practice, you should be able to practice well. If you are a judge, you should be able to now adjudicate the cases well. The fact of matter is that you should be able to do something really seriously, now sincerely and with all legal acumen and experience and knowledge. If you do not have knowledge, I think you will not succeed even as a lawyer or as a judge or as a legal officer or as a law teacher or as a law researcher. I hope, Purnima, you are hearing me. So even you are required to understand this fact. It's very, very important, I tell you. The learned counsel for petition only submitted the applicant was an illiterate lady and was totally dependent on legal advice from her counsel. Because of now even now learned people will not say this because I generally rely on lawyers and I do not want to involve in other things because teachers want peaceful mind to teach. So I do not want to fall in any controversy as such. I want to refrain from all those things. But unfortunately, you are dragged into that. So she could not file suit for a space. This is her plea. So will you punish her for this? Or will you exempt her or exonerate her? You will allow a concession to her? Obviously, I think you will allow concession. However, when she came to know about this legal defect, for amendment of plaint was filed. Learned counsel also submitted that the law on point is settled that a party cannot be put to suffer because of any wrong advice having been ordered by her counsel. Rather, the party should be allowed to contest their case on the basis of all the facts and evidence available on the file. This is what is the point. Correctly argued. Correctly argued. This is why I emphasize so much on reading of cases. And if you develop this habit, I tell you, everyone sitting here, those who find now reading of cases difficult right now, they will enjoy this later on, I tell you. And you will not believe that what you got in this class. I told you one day to listen to the topper's interview. There you will find one girl said that Gujarat judiciary topper. He said very clearly that I was forced to write one answer in the class every day, and I think that was the biggest preparation for me. And this is how you win match. This is how you become a judge. You should be forced to write because you are required to write in examination, men's examination, obviously. This is what we are required to do. We will be doing this in this class also. I will be giving you some questions to write and you will be asked to evaluate your answers. I will be giving you answers in the class itself. I will start it very soon. While arguing on this point, learned counsel for respondent admitted that the learned trial judge has rightly dismissed. uh, uh, no, it does not change the nature of case. No, no, no. It's all unnecessary points. They argue something. I do not find it relevant, so we'll read the next page. Whatever is relevant, I'll tell you. Don't worry. Now, here the court says, having heard the learned counsel for both the parties, and also having gone through the above said judgments, this court is of the view that the present case is to be seen in its entirety. Most of the facts are not disputed that the agreement of sale allegedly executed in favor of plaintiff on this. Target date for execution was this. Present suit for permanent injunction was filed by petitioner on this date. It is not disputed in any way that on plaintiff could have and should have filed suit for a specific performance and not suit for permanent injunction. Now controversies. We've seen that in the light whether the plea taken by applicant that she is an illiterate lady and was dependent on the legal advice rendered by her counsel and having received legal advice from her counsel, she could not file suit for a specific. Rather filed suit for permanent. Plea has been taken in the application for amendment of plaint. That on realizing her mistake, application for amendment of plaint was filed, which has been declined by the court. It is also not disputed that while allowing such an application for amendment, the court should be very cautious while deciding such application. As regards to the plea taken by learned counsel for the respondent that if the proposed amendment constitutionally or fundamentally changes the nature or character of the case, the same should not be allowed, is not strictly applicable. Now, this is relevant. The proposed amendment constitutionally or fundamentally changes the nature and character of the case, the same should not be allowed, is not strictly applicable in the present case. The only plea taken for seeking amendment is on the point that because of ill advice from her previous counsel, suit for a specific performance could not be filed, and only suit for a permanent injunction was to be filed. It is settled proposition of law that law of procedure is meant for advancement of justice and not to create obstacles for advancement of justice. So this is what is relevant, not to create obstacles for advancement of justice. The amended provision of Order 6, Rule 17 of the order which reads as follows. Above provision makes it ample clear that Order 6, Rule 17 commences with the words, the court may at any stage of the proceeding, and thereafter goes on to confer a power to allow either party to alter or amend his pleading where it appears to the court that the amendment is necessary. Amendment is necessary for purpose of determining the real question in controversy. The proviso by use of expression provided that no application for amendment shall be allowed after the trial has commenced appears to place an embargo on the power of court to allow amendment after trial has commenced. If the proviso were to end with this expression, it could be justifiably be argued that the pleading cannot be amended after the commencement of trial. The proviso, however, now this is very, very important. Now see this language. The proviso, however, qualifies the prohibitory expression by the use of word unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial, thereby clarifying that the embargo is not absolute and the court may, if circumstances so permit, allow an amendment after the commencement of trial. So please note down this point, very, very important. You use this in writing also, qualifies the prohibitory expression by the use of words unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before commencement, thereby clarifying what it clarifies, that the embargo is not absolute. Be careful. Embargo is not absolute, and the court may, if circumstances so permit, allow amendment after commencement of trial. So this amendment can be allowed even after commencement of trial. It can be allowed even after commencement of trial. Is this clear? The scope of Order 6, Rule 17 was discussed by Honorable in case of Ajendra Prasad Ji N. Pandey versus Swami. There was a sweeping amendment by which Rule 17 were wholly omitted so that an amendment itself was not permissible. Although sometimes effort was made to rely on section for extension of time for ultimately to strike a balance, the legislature applied its mind and reintroduced this. It had a provision permitting amendment in the first part, which said that the court may at any stage, but it also had a total bar introduced by proviso which prevented any application for amendment to be allowed after trial commences, unless court comes to the conclusion that in spite of due diligence, party could not have raised. It is this proviso which falls for consideration. Now Salim Bar. So he says, by amendment of 1999, this provision was deleted. This can be a good preliminary question. It has again been restored by Amendment Act of 22 of 2002, but with an added proviso. Now this time proviso. For amendment being allowed after the trial has commenced, unless court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. the proviso to some extent curtails absolute discretion to allow amendment at any stage. Now, if application is filed after trial, it has to be shown that in spite of due diligence, such amendment could not have been sought. The object is to prevent frivolous applications which are filed to delay the trial. There is no illegality in the provision. Under the proviso, no application for amendment shall be allowed after the trial has commenced unless in spite of due diligence the matter could not be raised before the commencement of trial. It is submitted that after the trial of the case has commenced, no application of pleading shall be allowed unless the above requirement is satisfied. That to shorten the litigation and speed of the disposal of suits, amendment was made by amending Act 1999, deleting Rule 17. This evoked much controversy, agitation all over the country, and also leading to boycott of courts, because now one of the most important rights are taken away. If there is any now mistake at the outset by the lawyer or by the parties, and then you do not allow them amendment later on to correct the errors, is it not going to be unjust? But the problem was this, that this provision is being misused by many parties. That was the issue. So we have to find out some way and means to prevent the misuse of this provision, rather than to already altogether delete this provision. Leading to the boycott of courts, and therefore by Civil Procedure Code Amendment Act 2002, provision has been restored by recognizing the power of the court to grant amendment, however with certain limitation, which is contained in the new proviso added to the rule. The details furnished below will go to show as to how the facts of the present case, so that the matters which are sought to be raised by way of amendment by appellants were well within their knowledge on their court case and manifest absence of due diligence on the part of appellants, disentitling them to relief. The error in raising the pleading as instructed was on the part of our counsel, who failed to incorporate the pleading and properly drafted the suit. So this is the main point. So this is the main point. Huh? A party reposes implicit faith in her counsel, and if a counsel commits a bona fide error, despite having received all relevant documents and instruction, a litigant cannot be punished for the error of her counsel. Such a party is certainly entitled to take a plea and make out a case for seeking amendment of pleading on the ground which is squarely covered within the meaning of expression due diligence. So the court says that it is covered under due diligence. I cannot say that the party was not diligent, because the lawyer has committed wrong. And this says further, in the present case is necessary for determining the real question in controversy. And the trial court should have allowed the prayer. In view, this court is of the view that the proposed amendment was required to be allowed by the court below so as to determine the real controversy. So this will be allowed. This is the judgment. This is the decision. So when you write a case, I have told you again and again, you can see Order 20, Rule 4 also, where it says that judgment will contain facts, decision, reason. No, fact, issue, decision, reason. So fact is there, issue is there, then the decision, and then the reason. Is this clear? This case is clear. I think Sarabjit Kaur, Sonia Mehra, you have already read. Mount Mary Enterprises versus Jeevaratna Medi Treat. See, these are different cases which will make your point clear. पे इसको नहीं डाला है क्या? Mount Mary, yes. Supreme Court of India. Amendment allowed. And see here, I tell you what is the fact. The appellant, now who is appellant, plaintiff, defendant? We are not concerned with that question, that's useless. A case is filed, then there is a written statement which is filed, plaintiff is filed, written statement is filed, and in written statement, the other party says that this suit is undervalued. The suit is undervalued. Now this party who has filed the plaint, he wants to correct the valuation of the suit. He wants to correct the valuation of the suit. And he wants to bring an amendment in his plaint. The question is, should he be allowed or not? So you can see the facts. First, he valued the property around 14 lakhs. Then he says that no, this property value is 1 crore 20 lakh. Then the other party says, amendment, rather the court says that the amendment was made at belated stage and by virtue of the said amendment, the suit was to be transferred to the High Court to its original site. If valuation is increased, it will go to High Court on original site. Means High Court will not hear it in appeal, it will be original in High Court because the suit valuation will be more. Now even today, if in Delhi the property value is more than 2 crore, the High Court has jurisdiction, original jurisdiction. So this is what is being said, that if you increase the value of the suit, it will go to High Court directly in original site. No. Now, on what basis you will allow amendment? So it says that, see, there is 1957 Supreme Court decision, and it was felt that all amendments should be allowed, which satisfy the two conditions of not working injustice to the other side, number one, of being necessary for the purpose of determining the real question in controversy between the parties. Amendment should be refused only where the other party cannot be placed in same position as if the pleading had been originally correct. But the amendment would cause him an injury which could not be compensated in cost. All right? So basic plea is this only, that the suit valuation is less, and even the other party in his written statement says that suit is undervalued, and now the first party wants to correct the valuation of the suit, and consequential effect is that the suit will go to High Court in original site, and that is why trial court has rejected this amendment on the ground that the suit will be transferred from this court to High Court to original site, and that is why this amendment should not be allowed. Because it will only change the character of the suit. Is it proper? Is it correct? The answer is no. This is not correct. The facts. Again, see, in judgment writing always, the judge is writing his judgment. Anil R. Dave Saab is writing the judgment, the facts. Appellant has described plaintiff, filed a suit, who has been thereafter described or for a specific performance in relation to a suit property. initially valued at this, initially, pehle. And thereafter realized the market value was more, filed application for amendment. Said application for amendment was rejected by trial court. Then the writ petition was filed by plaintiff challenging the order, rejecting amendment. He said petition has also been dismissed. The plaintiff had approached this court. So the petition was again dismissed by the High Court. The plaintiff has approached this court and prayed that impugned judgment, confirming the order, rejecting the amendment of plaintiff be set aside and plaintiff be permitted to amend the plaintiff. So that is clear. So trial court rejects, High Court does not give him relief, so he comes to Supreme Court. That is clear. The learned counsel appearing for plaintiff submitted that amendment has been rejected by the trial court for reason that the said amendment was made at a belated stage. So what is the ground? Made at a belated stage. See the argument. And the suit will be transferred to High Court on its original side. The two grounds have been made. At a belated stage, number one, and suit will be transferred to High Court to original side. And the appellant was also prepared. It has also been submitted by learned counsel that in normal circumstances, an amendment is always granted unless by virtue of amendment, nature of the suit is changed or some irreparable harm is caused. Neither nature of the suit was changed nor the defendant be put to any hardship. Correct? Neither nature of the suit was changed nor was the defendant be. This is your argument. The amendment was also not likely to cause prejudice to the defendant. Amendment which was sought to be made was just and proper because actual market value was this. On this basis, they have built the case. On the other hand, the learned counsel appearing for the respondent defendant had submitted that the amendment application amendment application was filed at a belated stage with an oblique motive. It is also to be noted here, see the judgment, how judgment. Defendant had already made an averment in para 30 of W as filed in suit number this, that the plaintiff had undervalued. Now defendant has himself said that the plaintiff had undervalued the subject matter. If in pursuance of averment made in the W as the plaintiff wanted to amend the plan so as to incorporate correct value, the defendant could not have objected to the amendment. And the defendant at least should not object to the amendment. Huh? The main reason, you just see this is funny. Main reason assigned by trial court for rejection was that upon enhancement of valuation, suit was to be transferred to the High Court on its original site. So how you are concerned with this? That is not a reason for which amendment application should have been rejected. This is the wrong reason. You understand the law. This is the wrong reason that suit will be transferred to High Court, and that is why I am rejecting this amendment. All amendments have to be allowed to satisfy the two conditions of not working injustice to the side, of being necessary for determination of real question. So is there any doubt about this? The answer is no. Amendment should be refused only where the other party cannot be placed in the same position as if the pleading had been originally correct. In our opinion, on the basis of aforesaid, the amendment application made by the plaintiff should have been granted, especially in view of the fact that it was admitted by the plaintiff that the suit property was initially undervalued. And by virtue of amendment application, the plaintiff wanted to correct the error and wanted to place the correct market value. So what is wrong in it? What is wrong in it? Tell me. So Mount Mary is very clear. They allow the appeal and they say that you can correct this. There is no order as to cost. This is the judgment. This is the decision of the court that he should be allowed amendment. Mount Mary. You read other cases, M. Ravanna versus Anjanamma. I give it to you to read. Amendment was not granted in this case. N.V. Ramanna and Mohan M. Santanagadar. This is 2019 judgment, and I'll give this case in your app, so please read it. Nothing great in this. Nothing great, my dear friend. Now, let me see, is there anything left and which I tell you? Sarabjit Kaur, I have already told you, reasoning. Usha Bala Sahab Swami versus Kiran Appaso Swami and others. It says that court said that it would be more liberal in amendment of WS than of plant. In amendment of WS, there can be addition of new ground of defense or substitution or alteration. An amendment of plant and the amendment of WS stands on different footing. It says that general principle that amendment can't be allowed to alter the materially substitute new cause of action or nature of claim applies to amendment of claim. It has no counterpart in principle relating to amendment of WS. Is this clear? So you can write down this point, amendment of WS. I take 2-3 minutes break and then I will begin again, and I have to tell you two very, very important points. Is this clear? कहाँ हो तुम? तुम कहाँ हो? अरे, मेरे को पता ही नहीं चल रहा है। भगवान। Really bad. See, this is what I said even earlier. Now, the person is sitting here and he is also not. So if one is insincere, everybody loses. This is applicable to entire country and entire state also, that if one of the teacher, if one of the doctor, if one of the engineer, if one of the lawyer, if one of the judge does not work properly, then everybody has problem. One of the officer, and most of them do not work properly. Really, really very, very bad. I did not say anything, my dear friend, you should not worry. I told you this case on page 74 about amendment of WS. This is Usha Bala Saheb Swami versus. I was asking a question, what is the rule on amendment of WS? Answered on page 74, and I said that rule of amendment of WS is liberal than rule of amendment on plant. This was some in substance of uh, what I said. Page 74, amendment of WS. Can you see this Bala Sahab Swami versus Kiran Apaso Swami? AIR 2007 judgment. That is what I was reading. This was from your material, page 74. Can you see this? This is what I was saying. So now I came to another question. Now I was discussing a point and I said that if a suit is filed for RCR and then this suit is being converted to file, this plaint is being amended to bring a case for divorce. So can it be done? So on this point, court said that see, reconciliation or restitution and divorce are two mutually opposite, diametrically opposite matter. Reconstitution of restitution of conjugal rights is basically now you are reconciling, and divorce is that you are now separating. So these are two mutually opposite things. So a suit for RCR cannot be converted to a suit for divorce. Petition for divorce. Petition for RCR cannot be converted into petition for, a petition of RCR cannot be converted in a petition of divorce. This is not possible. This is not possible because these are two diametrically opposite things. These are two diametrically opposite things. Is this clear? These are two diametrically opposite things. So this is not allowed. The court said very clearly. Then I come to another point, that what is applicability of this rule of amendment in a Specific Relief Act, or in Arbitration and Conciliation Act, or this writ proceeding. Now, how it will apply there? On that point, you can just see those acts. If you have this Specific Relief Act and Arbitration and Conciliation Act, I will draw your attention towards certain points which will be really useful for you, because if you are asked a question, and also you just see Order 6, Rule 7, I will raise certain question. Order 6, Rule 7. But first, let us discuss the point of application to arbitration. I start from here. Now, you know that in arbitration proceeding, the law is very simple. That it is the parties who are required to choose the law. Now, let us see this. It is the party. Arbitration Act says that a strict rule of CPC and evidence will not apply. This is very clear, because we want to give liberty to party to settle their matter as soon as possible. No? Now, for our purpose, Section 23 is relevant. Now, so you can see Section 23, subsection 3 of Arbitration and Conciliation Act 1996. Now, this Arbitration and Conciliation Act regarding this amendment, it says, unless otherwise agreed by the parties. So, if it is agreed by the parties, clear. Either party may amend or supplement his claim or defense. So, claim means basically plaint, or defense, that is WS, during the course of arbitral proceeding. So, when amendment is possible, so it says either party can amend his claim, which is substantially similar to plaint. And second, it says his defense, that is substantially similar to WS, no? And this is similar to plaint. So, either the plaint can be amended or WS can be amended in CPC. Similarly, your claim can be amended, defense can be amended. Either party can amend his claim or defense. When? So, it says during course of arbitral proceeding. During course of arbitral proceedings, unless arbitral tribunal considers it inappropriate to allow amendment or supplement having regard to the delay in making. So either party can amend. This is number one. Up to what time? During course of arbitral proceeding, not afterwards. So, during arbitral proceeding, now you cannot amend your this claim or defense in proceeding of Section 34, where arbitral award is being discussed, in 37, where you discuss regarding appeal, etc. No? Recourse against arbitral award. So, that is arbitration proceeding is finished. Now, may be made only by an application for setting aside such award. So, court, you go to the court in Section 34 and appeal, and appeals are live from following orders. So, this is appellate proceeding. No? So, here we are not talking about this, so we are not going to Section 34 or 37 of arbitration and during arbitral proceeding you can amend your claim or defense. So, there is no doubt about this. There is complete freedom to the parties. Parties can make their law unless otherwise agreed by the parties. So, if the parties agree, then they can do it. If they do not agree, if there is no agreement among them, then the arbitrator may decide. Then the arbitrator will decide whether it should be allowed or not. If the parties do not agree, then the arbitrator will decide this matter. And if arbitrator does not decide, then whatever is the law on the point, whatever is the precedent on the point that will be followed, law will apply. So first priority is given to the parties to decide the matter. The parties will decide this. That is why it is written, unless otherwise agreed by the parties. Clear? Here there is nothing like proviso of Order 6, Rule 17. CPC doesn't apply here. So it does not say that after commencement of trial it cannot be done. No, it can be done even during arbitral proceeding, from beginning to end. So this is the difference. This is the difference in arbitral proceeding. That is why I have drawn your attention towards this fact. Is this clear? No due diligence is to be shown. Proviso of Order 6, Rule 17 doesn't apply. CPC has no application here. So third point you can write, it is allowed to be amended during arbitral proceeding. During arbitral, it is allowed to be amended during arbitral proceeding. It is allowed to be amended during arbitral proceeding. It is allowed to be amended during arbitral proceeding. Allowed to be amended during arbitral proceeding. It is allowed to be amended during arbitral proceeding. Is this clear? Number 4, I said CPC does not apply here. So, rule of Order 6, Rule 17 or proviso, the limitation there of due diligence does not apply. Does not apply. Next. Next. This can be, unless the arbitral tribunal considers it, it can be disallowed if arbitral tribunal considers it inappropriate. Considers it inappropriate. They think that it is delaying tactics, it is just… this is what is in arbitration. Is this clear? Now, what in writ proceeding? I tell you, in writ proceeding, generally there are high court rules, and if you read high court rules, you will find that in high court rules, generally it says that CPC will be applicable, the rules of CPC will apply. So that doesn't pose much difficulty. In writ proceedings, Order 6, Rule 17 will apply, because high court rules will generally provide this, and that is how you have learned the law of Order 6, Rule 17, so that you can apply there. Now, what in case of a specific relief act? A specific relief act, my dear friend. A specific relief act. Specific relief act is very, very important that way. I tell you, application to specific relief act. Application in a specific relief act. So if you see specific relief act, my dear friend, now particularly it says Section 21, subsection 5, I want to bring your attention towards this. Section 21, subsection 5 of Specific Relief Act 1963 says, no compensation shall be awarded under this section unless the plaintiff has claimed such compensation is in plaint. You know that in many suits for a specific performance, plaintiff may also claim compensation for breach in addition to such performance. Section 21, subsection 1 also says that. You can claim a specific performance. You can claim further compensation as well. Specific performance and compensation. Specific performance and compensation. So suppose in a case a specific performance suit has been brought, and towards the end you find that the specific performance will not be allowed because you have not been able to prove it by evidence that you have a genuine case. But you may get compensation, but you forgot to claim compensation because you are sure in the beginning that I'll get a specific performance. Now the question arises, can you claim compensation? So now in this regard, section 21, subsection 5 says, no compensation shall be awarded under this section unless the plaintiff has claimed. So you did not claim it. Now your right is gone. But proviso further says, where the plaintiff has not claimed any such compensation in the plaint, the court shall, at any stage, again at any stage, so this is quite wide, of proceeding allow him. Again, it is not bound by or not barred by or not restricted by Order 6 Rule 7. Allow him to amend plaint. Allow him to amend the plaint. Any such compensation, the court shall at any stage of the proceeding allow him to amend the plaint on such terms as may be just. For including a claim for such compensation. Court shall at any stage of the proceeding. Court shall at any stage of the proceeding allow him to amend the plaint on such terms as may be just for including a claim for such compensation. Court shall at any stage of proceeding, even towards the end. So there is no restriction like Order 6 Rule 17 proviso. You must be very clear on the point. Court shall any stage, even if argument is done, the case is towards judgment. Is this clear? Is this all right now? And I would like to quote another provision of a Specific Relief Act, which may also be relevant here. This is section 40. Now what section 40 says? See, damages in lieu of or in addition to injunction. Again it says, subsection 1, if you see, plaintiff in a suit for perpetual injunction under section 38 or mandatory injunction under 39 may claim damages either in addition to or in substitution for such injunction, and court may, if thinks fit, award such damages. So you can claim in addition or in substitution damages in claim of injunction. Now it says further, no relief for damages shall be granted under this section unless the plaintiff has claimed such a relief in his plaint. No relief for damages. shall be granted unless the plaintiff has claimed. So similar to section 21 subsection 5. So you will have to claim, provided where no such damages have been claimed in the plaint, the court shall at any stage of the proceeding allow the plaintiff to amend the plaint on such terms as may be just for including such claim. So again here it says the court shall. So section 40. Section 40 of SRA, Specific Relief Act 1963. Now again it says, section 40, subsection 2. Sorry. Again it says, where no such damages have been claimed in the plaint, the court shall. So, court shall at any stage allow plaintiff to amend the plaint on such terms as may be just. As may be just. Are you getting the point? Is this clear? Is this clear? Is this clear, sir? Everybody. So this is again similar to that point which we raised earlier, which we said earlier. So section 40. Now then another point which may be again very important, amendment of pleading. Whenever it is read, in most of the cases you ignore another provision which is relevant in amendment of pleading, and that is Order 6 Rule 7. Order 6 Rule 7 departure. Order 6 Rule 7 departure. This is very, very important. Now the point is that can you raise new ground? Can you raise inconsistent claim by way of amendment? So if you see, generally you read about this fact that you cannot raise new ground of claim, or you cannot do this, you cannot do that. There are so many prohibitions. No? There are so many restrictions. There are so many restrictions, there are so many prohibitions. Where is my Bare Act? Where is my Bare Act? Bare Act CPC का Bare Act. देखो कोई और Bare Act लाओ CPC का, इसमें तो नहीं छोड़ दिया. So Order 6 Rule 7, if you read the law in Order 6 Rule 7, now it says, rule says, no pleading shall raise any new ground or allegation of fact inconsistent with previous pleading. So this is the rule. But it says, it can be done by way of amendment of pleading. It says, no pleading shall raise except by way of amendment, new ground. So you can raise new ground. You can raise allegation of fact inconsistent with previous pleading. It is not barred. Order 6 Rule 7 allows you to raise inconsistent plea, to raise allegation of fact which is inconsistent with previous pleading. This is done. So what it says, now you may raise a question that, see, if I allow this to be done, like we have read some examples where I have said that there can be some situation where your claim may be time barred. If it is allowed by way of amendment, then it will relate back. There is a doctrine of relation back in amendment of pleading. So if it is allowed, if amendment of plaint is allowed, so then it will relate back to the original date. So this will be considered within limitation. So suppose a claim is today time barred. and I allow amendment of pleading. And this amendment of pleading results in such a situation where that claim which is time barred today comes within this, and by way of amendment of pleading, this claim will be brought in the court and court will be required to give decision on the point. Now, so can we do this? Yes, we can do this. It is allowed. There is no dearth of power of court. Court is not deprived to do this. Court is required to do justice. But the fact of matter is that limitation is a mixed question of law and fact. So court will see it in the merits whether the claim is time barred or not. If the court finds that this claim is time barred, the court will take the call. But it is a mixed question. This is not relevant for deciding amendment of pleading. Amendment of pleading will be done. If court finds that this is necessary for determination of real controversy in question, if court finds that it does not prejudice to the other party, it does not prejudice the other party, and if there is prejudice, it can be compensated by cost. So to that extent, it is allowed. So even if your plea is barred by limitation, now in one case what happened, earlier we admitted and now we want to withdraw admission. So this is inconsistent. Earlier we admitted, like we admitted that the suit property is joint family property, but now I want to withdraw that admission. Can I do it? This is as per Order 6, Rule 7. You can do it. If the court is having this understanding now that it is necessary to find the truth, if amendment fulfills that, we are there to do justice. We are there to do things which will bring forth the truth of the matter. So court can do it. There is no bar. It is permissible, provided it should be bona fide, it should not be mala fide. So at the end of the day, there is no want of power in the court. They can allow you to put forward new or inconsistent claim. This is very, very clear. So even inconsistent plea is allowed. Pleading new cause of action is allowed. Withdrawal of admission is allowed. So you forget the old law and you develop this new law. This is departure. Order 6, Rule 7. So whenever you read this Order 6, Rule 17, you visit Order 6, Rule 7 also. This is very, very important, my dear friend. Order 6, Rule 7. Order 6, Rule 7. It says, no pleading shall accept by way of amendment. So by way of amendment, it can be done. Raise any new ground of claim or contain any allegation of fact inconsistent with previous pleading of the party pleading the same. So this is allowed. This is permitted. This is permissible. Order 6, Rule 7. Is this clear? So this is how we have finished this amendment of pleading. We'll discuss further more topics, but I have told you to solve the question and to bring it to my... Now some people have brought certain questions to my attention. I will be answering them one day. So don't worry, you please drop your questions. I will be answering them one day. I will take out the time and I will answer all the questions. Is this clear? Today we have exceeded the time limit. I hope you must have been exhausted now. I am too. If you have any doubt, question, you can ask me. Otherwise, you please keep dropping your question. I will see it someday and I will answer them together. But you keep on solving the question. Like amendment of pleading is very important. You can solve the question immediately. You read it and you solve it. Amendment of pleading. I will especially request you to solve the question of Order 2, Rule 2 and this Order 6, Rule 17 and that written statement and set off and counter claim. They are important topic. Rejection of plant. Very important topic. Section 9, 16 to 20. Very, very important. Oh, my dear friend, please let me know if you have any doubt, question. Otherwise, okay, bye-bye. अब मैं कोई सवाल नहीं Shrestha, Mahendru, Aditya, Sonia, Vaishnavi, Ayushi, Aarti, Shant, Jeba, Vaishali, Priha, Shashank, Aditya, Vijay, Shrestha, Shreyas, Jia, Dibyanshu, Harsh, Varun, Muhammad Amir, Prashant, Dia, Apurva, Gaurav, Neha, Tarun. Only few people are active in class. Gazala, Ghazal, Kirtiman Divedi, Neha Kumawat, Mukta Gupta, An Annapurna Bhaskar, Sambhavi, Abhishek Thakkar, Anas, Kanika, Utkarsh, Kashish, Abhimanyu, Akshat, Sunil, Priyadarshini, Jeba, Dibya, Kiran, Ayushi, Mayank, Pragati, Sonu, Himani. Great. Can we say that order 6 rule 7 is exception? ऐसे नहीं बोलना है, ये एक्सेप्शन कोई नहीं है, बट ये लिखा है कि भाई डिपार्चर्स भी हो सकते हैं. ऐसा थोड़ी लिखा ऑर्डर 6 रूल 17 में देयर कैन नॉट बी एनी डिपार्चर. ऐसा लिखा है ऑर्डर 6 रूल 17 में. सो हाउ कैन आई से एक्सेप्शन? सर कभी आपसे मिलने आ सकते हैं. बिल्कुल बिल्कुल, हम आपसे मिलने आ जाएंगे. रजत, वी कैन नॉट से दैट दिस इज एक्सेप्शन. लुक्स लाइक एक्सेप्शन ऑफ कोर्स, बट कोई ऑर्डर 6 रूल 17 में लिखा नहीं है कि देयर कैन नॉट बी इनकंसिस्टेंट प्ली. That is principle which we have propounded. Order 6 rule 17 doesn't say that. Obviously exception तो लग ही रहा है. That you cannot do in order 6 rule 17, you can do in order 6 rule 7. But we cannot put this in such a strong word. Of course exception है, कह सकते हैं, कोई issue नहीं है उसमें. But order 6 rule 17 में कहीं नहीं लिखा है कि you cannot raise. वो तो हमने principles बनाए हैं. Thank you. Bye-bye. Enjoy your day. Please revise your class notes. Please revise your class notes carefully and please read material carefully, my dear friends. God bless you all. Be sincere, be on time. True nationalism is that you do your duty with professionalism, with full dedication. Is this clear? Okay, bye-bye.